Right then, sir. I'm just going to talk briefly about this Ethel Margaret Self petition because I've got this report now that I wanted to get, and her petition is actually in here, right? One thing to mention before I start on this is this: that Mr. Viant MP, he was on this committee by the looks of it, and this is 1939, right? Now remember that in the 1944 committee report, which is several years after this, 1940, 1, 2, 3, 4, 5 years. 5 years after this, Viant is on that petitions committee again, and that's the report, the 1944 one, that says that he admitted they were doing things wrong. He admitted that they'd been referring petitions to governmental departments without first getting votes in the House on it or other committee votes. So that was like a confession of wrongdoing by Viant 5 years after this, right? So that we need to take that into account. Now, I'll just read you out from this, right? So this is Ethel Margaret Self's petition, right? So she says, so this is what the committee say, or what she said to the committee. The petitioner alleges wrongful conviction of a charge of driving a motor vehicle to the danger of the public as a result of willful false evidence by witnesses for the prosecution and suppression of evidence by the police concerned, right? Now, it says the petition of Ethel Margaret Self, and in brackets it says Mr. Christie, but on the number of signatures ascribed to it, there's just a star. It doesn't say any number, so we don't know if there are any more. I don't know why they've recorded this Mr. Christie, but we know that she gave about 5,000 flyers out around Yarmouth and Lowestoft area. That's where she was charged, although she was from Long Stretton, which is just below Norwich. Now this is what the note. It's got a note underneath it, right? This is what the note says. This is from the committee, right? It says, your committee have not, in the case of this petition, reported to the House the total number of names appended thereto, as the form of the petition does not permit signatures other than that of the petitioner. The additional signatures therefore have not been counted. Now, they've got it down as a petition of redress of grievance, right? They're saying that they're putting it through as a redress of grievances, right? So that's what it says. Now, this is the 1856 standing orders, right? This is the public business, right? And under presentation of petitions, we've only got these here, right? So we've got those in here. So it says that every member offering. So these rules weren't there until 1842. That's important to understand, right? Didn't have any rules for this. And going back further than 1842, there wasn't a difference between public and private business either. There was only different types of petitions, like for religion or like here, pecuniary. I can't ever pronounce that. Pecuniary penalties. Applications for money, trade, that's anything to do with business, religion, right? Things like that. Prayers, public business. So, right. So these, George Strickland also in the 1832 committee report voted against these rules, but there was quite a lot of majority of the House voted in favour of them. Strickland is the one who was noted saying that some of the petitions could be very strongly worded because there wasn't actually any official etiquette for what petitions should or shouldn't say right at the time. There wasn't any real proper rules for what the petitions should or shouldn't say. So, that every member offering to present a petition to the House, not being a petition for a private bill or relating to a private bill, so this is not in the private business, in the public business, before the House, right, do confine himself to a statement of the parties from whom it comes, of the number of signatures attached to it, and of the material allegations contained in it, and to the reading of the prayer of such a petition. Right, so that's all of them except private bills, right? These are rules for reading out any petition as long as it's not a private bill. And it also says with allegations. Now, if you've got a petition of grievance, right? A petition of grievance has allegations. These are allegations, right? These are allegations. So actually, it says that you still count the number of signatures attached to it and of the allegations, right? This is for all of them. So actually, I think that the signatures are still relevant to petitions with allegations, right? So I think that committee was wrong in this statement, and that they proved to have been wrong in 1944, 5 years later, when Viant says they were doing certain things wrong, right? Now, the next rule here, that every such petition not containing a matter of breach of privileges, well, Ethel Margaret Self's case wasn't, her case, she wasn't already using Parliament in the first instance. She didn't already have a cause to Parliament before she got prosecuted for her driving, right? So that's not, that doesn't qualify, that doesn't disqualify her petition from having the signatures. Not containing a breach of privilege of this House, on which, according to the rules or usual practice of this House, can be received. Well, if it's in this journal, it can be received, right? If it's in this journal, it can be received. But the question is, what is the usual practice, right? Be brought to the table by the direction of the Speaker, and shall not allow debate or any member to speak upon in relation to such petitions, but it may be read by the clerk at the table. Right. Now, then you've got this clause here, which is that in the case of such petitions complaining of some present personal grievance, for which there may be an urgent necessity for providing an immediate remedy, the matter contained in such petition may be brought into discussion on the presentation of the petition. So that means they can actually talk about it there and then and provide a remedy, but they can talk about it to provide a remedy, right? Now, Ethel Margaret Self's petition, it did have an urgent grievance in it, but she was prosecuted in 1936, and she didn't end up doing this until 1939. Getting a petition in here wasn't until 1939, so it can't have been that urgent, right? Well, and they definitely didn't, by the time that it was in the newspaper as well, they hadn't provided a remedy. So they definitely didn't treat it as if it needed an urgent remedy, because I don't think they'd provided one from what I know, right? Or, well, we've yet to find out if they acted on it, but World War II started off, so that might have intervened in it, I don't know. But this personal grievance clause here, it's not to be treated any differently from petitions under this clause, other than it's presented under these rules, but if it needs an urgent remedy, it can be read out straight away. It's only the ones that John Tinker said in 1944 that don't need an MP to sign it, that are in a judicial matter, that can be presented at the bar. Now, whether Ethel Margaret Self's come under that rule or not, that it doesn't need an MP to sign it, But that doesn't mean to say that she can't get any signatures on it herself from other people, right? Because this is a good example here. This is American, but this is 1934, so it's not far off around the time when she is. In America, they did these petitions for parole, right? So that's judicial matters. And in America, with the White House, they've got a lot of, petitions for pardons and paroles. It's all feeding into the White House, but it's all adopted from our system, right? And you get signatures from the public. You get signatures from the public to vouch for your good character and good standing in the community, right, for parole. So I can't see why, if it's a judicial matter like the parole one, which the American system's adopted from the UK, I can't see why the signatures won't be significant or to be mentioned or attached to it, right? Unless the people didn't want them in the journal who signed it, but why would they sign it, right? So that the parole petition is a good example. I've just done it in larger letters here so you can read it clearly. Every member offering to present a petition to the House, not being a petition for a private bill or relating to a private bill before the House, do confine himself to a statement of the parties from which it comes, of the number of signatures attached to it, and of the material allegations contained in it, and to the reading of the prayer. Every member offering to present a petition to the House. So that doesn't say that the member signed it either. That doesn't actually say that the MP themselves has signed it. That just says that that the member is offering to present it. I mean, if John Tinker said it was judicial and the MP didn't need to sign it, it doesn't mean to say that the MP can't present it, right? Surely. Now, what we've got here, this is the 1972 to 1973 committee report, and this is just before they abolished the petitions committee, and then they had all petitions starting to be referred to ministers for comments, and that lasted all the way up till 2015, even for a little while they had e-petitions, right? Now, this is a collection of all the rules from the journals, particularly some of them from before, when these were even introduced in 1842. It tells you the dates of when these were actually put in the journals, these resolutions, if you want to call them resolutions, right? But in the 1832 committee report, it says that resolutions sometimes were only for one session and didn't stand like standing orders and be retained in the rules and carried over to other parliaments. They seem to think that they just made different ones up for each session as they needed them, right? And they didn't carry over because some of them replaced the previous ones. Now, and they're all in the 1832 report. Maybe I should have printed that out as well, but I didn't have time. Petition will be presented to the House. Everyone presented a petition. That doesn't say it's got signatures on it. Petition of the House must begin with. Right, that's just the layout of it. Every petition must contain a prayer at the end thereof, setting forth the general object of the petition or the nature and relief asked for. I'm starting to wonder if the prayer is like, in a legal document, when you've got statement of truth in an affidavit, you've got to have the statement or truth, or I do solemnly, sincerely declare that the facts that I say are the truth, right? Or like a proper legal document, a sworn document. The oath in the normal petitions is, and in duty bound your petitioner shall forever pray, and etc. And etc. is meant to be an abbreviation of all the rest of the oaths and affirmations. I'm starting to wonder if whether or not this originated from the fact when it had to contain a prayer, it had to contain the oath, because the oath is part of the prayer. Because if it's in duty bound your petitioner shall ever pray, and etc., if you put that sentence or line in, then you've got a prayer in it because you're praying. You automatically has the prayer in by putting the oath and affirmation. I'm starting to wonder if there's a bit of a confusion in this sort of like, it's got to have a prayer in it, like all affidavits and legal statements to be valid have to have the oath in it and you've got to swear them, right? I'm starting to wonder if it's got a connection to that. But generally, a prayer is like you're asking for something, which, if you want to interpret it the other way, like it isn't that one-line sentence, then it's like you've got to actually be asking for something. But most petitions are asking for something, or at least presenting a remedy, and it's obviously that you want a remedy for solution, because so they're always talking about, deciding what committee it's best to go to, or how to even solve the grievance or problem. If they don't always know how to solve it, or have got to think about how to solve it, then you're not necessarily asking for a specific resolution yourself. So, I mean, if you were, then it would be clearly obvious where it was going to go to and what we're going to do with it, I suppose. Right. Now, this is when we get into some investigation work now, right? Because we need to look into this to check things, right? Point number 6 in the rules, right? This is meant to be the rules from the journals giving the dates of when the rule was created and referring to which journal that they made the rule in, right? Now here, right, number 6, it says every signature must be written upon the sheets upon which the petition itself is written, and not pasted there upon or otherwise transferred thereto. But that's for the House of Commons rule, not the House of Lords. Right, here, number 5, sorry. Every petition must be signed by at least one person on the skin or sheet on which the petition is written. See the House of Commons Journals, 1817, March the 12th. The first signature should be written at the foot of the petition, right? Well, the signatures at the foot are usually from other parties, like supporting parties, because at the top of your petition, you write the humble petition of, and that's when you write your name and address to say who it is, right? And that's meant to be already identified you. And when you write your name, you're writing it in your own handwriting, because they were all handwritten anyway. And I think that the ones at the bottom are meant to be the supporters, right? The supporters, they stick to that form in the Scottish Court of Sessions form 14.4, where at the bottom you have like your sponsors or supporters, right? Now, this is the thing with this, right? If you actually go to this journal where it says the 12th of March 1817, this is from the 12th of March 1817, and I've actually looked at the journal itself. It says the House of Commons Journal for the 12th of March 1817, volume 72, does not contain specific newly drafted resolution on the rules of signatures. So it says that it doesn't actually contain this rule here, but rather reflects the House's ongoing strict and highly contested scrutiny of the mass petitions submitted during the period, specifically regarding whether the signatures were genuine or frauds. During this period of intense political repression, including the suspension of habeas corpus, the House of Commons was actively investigating petitions for reform. Petitions for reform utilised ruled spaces for signatures, and sheer volumes led to changes regarding the legitimacy. Debates focused on allegations that petitions were added without authorisation, or the petitions were being rigged through mass printing and forgery. While not a single named 12th of March resolution, the House upheld the right of members to reject petitions that appeared suspicious in their signatures, often requiring them to lie on the table. Now, so when you actually look at the journal, there is no resolution. There isn't a resolution on the 18th of March to say that it must be signed, right? There isn't. There isn't to say it must be signed. What it does say in that journal is that they did take note when it wasn't signed, and they noted if the signatures might be dubious. In this report, there's I don't know if it's the police pensions petition or one of the other ones, and let's just try and here, 214,580 or something, I think it is. Just have a look, because it's not printed very, it's printed only lightly in ink. 216,389 signatures, right? Oh, that's the visection petition, the prohibition of visection, right? And it's actually talking about whether those signatures are legitimate. And what it says in here is it says that any signatures which look dubious or like in the same ink or the same handwriting, they discounted them, but they still printed the petition and it was still accepted. So that's proof that if all of the signatures are not invalid, if some of them are invalid, then only the valid signatures count. Notably, the 38 Degrees website have been taking people's petitions down if they haven't got valid signatures or if even some are invalid, yet they've got no right to do that. They're only a publisher of petitions, and the evidence is ours, and then they have got no judicial capacity to make determinations on it. And even with some signatures that aren't correct, it's still accepted and put in the journals, and that's the whole point of checking them. So 38 Degrees are acting illegally, right? Now, that every member offering to present a petition to the House, not to be in a petition probable, can find himself to a statement of the parties to which it comes from, the number of signatures attached to it, and other material allegations, right? So, now, the thing is that if you check the history of petitioning, right, in the 1832 report they talk about this, and what they say is that George Strickland gives evidence to Robert Peel, and they say that, well, petitions didn't used to be signed. Petitions didn't actually used to be signed, right? And they were just drafted, written on behalf of a community or the commonality or an area or a village or a group or even an individual. And that evidence for that is in the Observation of Due Process of Law 1368, where the commonality put forth their petitions. The commonality were just the public. The commonality ended up actually becoming the commons after a while, and instead of just the public, the petitioners handing their petitions in, the commons went to hand them in on their behalf and became the House of Commons. And really, the House of Commons is only a representative body, like the House of Representatives, in a way that. And when the Speaker's petitioning the King for all the rights and privileges, it's like when you and me pick up a pen and petition for the rights and privileges, he's only getting it in the same capacity because we're sending them in there, right? So the House of Commons are only so much the commonalities as much as we were and are the commonality when we put forth our petitions to our MPs to present them on our behalf in London, right? Because they're appearing there to present them to the King on our behalf. And when they put a bill through Parliament, really it's meant to be the whole public who have supposedly decided on it, and then the MPs have done the vote on it, which meant to represent what we want, and then they hand it to the King, and then that's the petition to the King, and the King approves it. No really different from if you or me handed our petitions to the King, and he actioned or approved it, right? And it was only when some people were putting petitions on behalf of the whole community and the King didn't believe the petition that all the community really did want what they're asking for. So if they get all the signatures on there, it's evidence and proves it that every single person is asking for it. So it's only really evidence, right? And you didn't need or require all those signatures. You only really need them if someone doubted it, or if you needed to prove that it was a particular amount of people asking for it. If it's a request for an individual, you don't have to prove that other people support it. Now, if you write your name at the top, the humble petition of so forth and so forth, you're writing your name there, so it doesn't necessarily need to be it. It's usually the supporters were at the bottom, but here it says that on the foot. Now, in this journal here, 1817, they still weren't requiring them to be signed, but all it means is that there was questions of legitimacy around it, and they had to decide whether it was legitimate or not, and if the real people who you're saying it is on behalf of really do support it or not, or if you're just pretending that they do, right? So some of them were being signed and some of them weren't, but they were still could be accepted and actioned, right? But here, you see, it doesn't say in the standing order originally that it has to be signed. It says every member in offering to present a petition, the member presents it, and he says that he confine himself to a statement of the parties from who it comes. Well, it'll tell you from it's the humble petition of whoever, and of the number of signatures attached, if there are any. It doesn't say that they have to be attached. It only says that inform them of the number of signatures attached, if there are any, and what the material allegations and what the prayer of remedy is. But usually the prayer, I think, is connected to the oath and affirmation in a way, like with your affidavits, but there is some debate around that. Now, the other thing to point out in here, we've got a rule. Every person signing a petition must write his address after his signature, or his signature will not be counted. The order of reference, nor will signatures which shall appear in the same handwriting. Well, that's what they were saying in here. So if there were some of them in the same handwriting and in this report, then they won't be counted, right? But it still doesn't say that every person has to sign on a petition. It only says every person who's signing it. That's every person signing it if they do sign it. Every person signing it if they sign it. Doesn't say that they have to sign it, right? Neither does it here. It says every petition must be signed by at least one person on the skin, but you're saying that was a resolution. But there is no resolution. There isn't a resolution for that date at all. And another thing to note is here, number 14 says every petition must be respectful, decorous, and temperate in its language. Now, there's no reference to any standing order there at all. There's no reference to any journal or standing order when it was introduced, because there isn't a rule or standing order when it was introduced. There isn't a rule for the language in the standing orders, and there isn't it in now. It's not in now either. Now, that comes from Erskine May, because in 1832, George Strickland said they're sometimes very strong worded, and Erskine May, in his own personal book, suggested that they should be respectful, decorous, and temperate, right? But there's no standing order rule introduced in 1842 to make that the law, although it did appear in the Manual of Procedure in Public Business, which was a House of Commons rule book, which was started in around 1904, I think it was, until 1987, and then discontinued. So in the standing orders now, there aren't actually any rules for the language. The only the set statute law that it's anchored in is this 1368 observation of due process of law, which says that petitions are according to the old law of the land. According to the old law of the land. That's the established tradition and usual practice. It has to be the established tradition and usual practice because it's legislated in law. It's actually set in law in the law of the country. It's not actually set or anchored in standing orders. It originates and anchors in observation of due process of law, right? And that's the same as any if you have a witness statement in a court and, you have to give evidence, like you might have to account on what someone has said, that they swore or they used foul language or they attacked you or whatever. So I have seen evidence in some petitions from the archives where the House of Lords weren't happy if people were talking quite using intimidating language. But let's remember, the king was prosecuting people for petitions that he didn't like Henry Burton and John Pym. William Prynne and Henry Burton got prosecuted and committed for bringing particular religious matters that the king didn't like, and they had the whole seditious meetings and sedition. If you spoke badly about the king and people overheard you and the 2 or 3 witnesses, you actually would get prosecuted, like for treason, for speaking against the king. Now, after 1688, the Bill of Rights, the subjects have got the right to bring grievances against the king without being prosecuted, which includes in the petitions, right? And, but you also had Stroud's Act from 1215, when people were meant to be able to speak freely in matters of parliament, but it seems like the king wasn't upholding that too well. But they were actually saying in the Commons that, you can't speak disrespectfully about the king, but at least you weren't getting prosecuted for it. Now, all of the Privy Councillors have got an oath that they will not cognise anything, wrong to do with the king or associated to the king, and if they do, they will pass the information on to him. So it's clear that we have actually got complete and total freedom of speech for political matters, because Stroud's Act, Stroud's law was supposed to be enforced, but the king wasn't upholding it in matters concerning Parliament for freedom of speech, really. And this is one thing in the 1688 Bill of Rights, where not just the petitioner is free from prosecution for their causes, what they bring, their cases. Obviously, the mercenary processes were meant to be protected before the Bill of Rights, if that's what you're doing, right? But the freedom of speech of members of Parliament in Parliament, that's obviously because they're always doing casework all the time, right? But you don't need that provision for freedom of speech for our petitioning out of Parliament, in our promotion of petitions, soliciting in public, because the Bill of Rights, the Bill of Rights right to petition article protects you from all prosecutions, clearly including free speech and anything else altogether. So you don't need that specific article on free speech that they've got after it, which is for the MPs when they're in Parliament, because all prosecutions are illegal, including ones for, like, for speaking about Parliament matters, like in Stroud's Act, and there are many acts of law which embody that, like even the Obscene Publications Act, and there are other laws as well. There are plenty of laws around that freedom of speech. So that the right to petition applies to the writing in the petitions as well. And like when you fill a legal form in, sensitive ones complete, and a witness statement, an oath, you can't be prosecuted because it's legally privileged to the court, right? So it's meant to be on the same status. Now, if Parliament don't like the evidence, well, you're providing evidence so they can investigate something properly. It's not about publishing it. It's about providing the evidence to Parliament so they can act on it and investigate it, right? And the publication part of it, is like they used to summarise that if they wanted to put it in shorthand and change it, unless they published it in full. So there was a safeguard against that, and it actually ended up, by the time you get to the 1930s with the journal, I couldn't find this in the journal because it didn't even say that Ethel Margaret Self had submitted a petition. It just says a public petition was presented in order to lie on the table. You don't know anything from that. And, in the 1800s, they were printing the allegations from the election petitions or any other allegations, and the names of the parties, and by the 1930s they didn't want to publish or show anything. So I don't know why the current modern Parliament pledged to have more transparency around 2010, I think it was, or it might have been a bit later. They pledged that there was going to be transparency and accessibility for e-petitions, but it's ended up being very opaque and not transparent. They don't want us to see all of the petitions. The majority of the people who bring them are censored and rejected, so the majority of business is rejected, and even the ones that are published, they're putting propaganda out and misleading us that you can't do petitions about honours when they've got a forfeiture committee, and that there's evidence that there were petitions about forfeitures or honours. In 2006 to 2010, e-petitions was the most popular subject in the statistics, and now the figures are going down. They're making it look like people aren't angry, that people aren't petitioning about things, when there's never been as many people as angry with this government, and in the sessional returns the figures look lower. So what was the main point in this talk was that in 1939 they're saying that the type of petition that Ethel Margaret Self brought of a grievance wasn't privilege grievance, it was just a grievance in a judicial matter, that it cannot and should not attach signatures, which is wrong, because it should be the same legal situation as these parole petition for parole. And there's actually nothing in here that says that the petitions that are brought in under this first rule are still the petitions which some of them only have the additional factor of, if it needs an urgent remedy, it can be acted on, but only if it's urgent, it can be acted on. But that doesn't change anything to do with what signatures are attached to it at all, right? And there isn't actually any rule that it has to have signatures, only that if you do have them, they've got to have the name and the address on so they can check them. But there's still nothing which actually requires it to be signed even by you, even at the bottom. If you check up on all these regulations, because when you're writing it out, you with your hand, theoretically in paper, you are ascribing and signing your name at the top. So the bottom is meant to be the supporters, really, and I've seen some evidence of that, like with the Bedfordshire petition, which was complaining about road workers not maintaining the highway. That was a grievance, and it was signed by a certain number of people and some constables at the bottom, right? That's an example. But the 1832 committee report says that petitions didn't used to be signed, that the commonality gather together and they get someone to write out their grievances, and he says it's from all these people, and then you take their word from it, unless the king for it, you take their word for it, unless the king says, I don't believe you, or Parliament say we don't believe you. And that's the basis of the Inquiries Act 2005, Section 1A and B, which is like, it says, if it should appear to a minister that there is evidence of public concern, he may have an inquiry. Well, what is the evidence? What evidence proves public concern, right? Not just a newspaper saying, I think the public are concerned. Maybe if the newspaper said there was a riot and loads of people turned up and they had banners saying, free Lebanon or something, right? But even if the newspaper says it, even if the newspaper says that, how do you know that they could have just took a photograph of anyone? There might have been 3 people who had banners saying, Lebanon, unless you're actually there in person and hear them shouting, right? So the newspaper's not necessarily hard evidence. It's only still hearsay until you actually get the signatures of the individuals. It depends what you want to prove, It depends how valid you want the evidence to be. How provable is it? But the petitions don't have to be, as long as you've got your name on the top or it says who it's from, it's usually meant to be taken for granted if it's checked and validated, because every petition has got to be investigated anyway. Obviously, they're not going to act on it if your facts aren't true. because usually they would have corresponded with people in the same way that normal courts do now, and they had those triers of petitions, remember, as well. So I don't think that they're right in this committee when they say that they shouldn't ascribe the signatures to Ethel Margaret Selfs. And my opening point was that Mr. Viant, who was on that committee, is later to be found in 1944 saying that, we've been making some errors and mistakes, at least by referring to departments. So maybe he made more mistakes than what he said. Ironically, the number 10 Downing Street website, 2004 to 2006, did refer petitions straight to government departments and seems to completely bypass the Chamber of Parliament, which does make it judicially neutered in a way. I think that's what they're trying to aim for, to judicially neuter our public petitioning. Because that's the way it's going now with the current e-petition service, and completely opposite to all their promises and pledges of opaqueness and transparency. They don't want anyone to see or know anything. It's the public petitions are meant to be like COP10, when you merge parties together, when you join them, particularly if they've all signed it. On the ones when they do sign it, and when they have signed and proof on it, that's meant to be legally join parties together, right? Like a COP10 form, but courts aren't recognising that. If some petitioners get prosecuted, their other petitioner colleagues are meant to be able to help them out and make representations on their behalf, because you're prosecuting a cause. You're not actually meant to be prosecuting the individuals in their normal capacity as a citizen. You're meant to be prosecuting them like, it's like the needs of other cases, and the overriding objectives. And a lot of magistrates who are very poorly knowledgeable about the law and judicial processes don't get that, and the court staff, the clerks and the court managers don't understand that and won't let people make representations. In fact, the police, when you ring up, they don't let you speak to people in custody. But if you're a petition campaign group and you need to get one of your co-petitioners out of detention on privilege, you need to speak to them, and the police aren't letting people do that at the moment, but they shouldn't have even been arrested anyway in the first place. So there are a lot of issues, but I just wanted to raise this concern about this Ethel Margaret Self petition and the signatures ascribed. But I thought I'd talk about the fact that whether it does or does not need signatures, and about the etiquette as well, while we're at it.